So we were solving the previous question of AIBE 15 and we have already discussed up till question number 50 and we will continue from question number 51. What question number 51 says section 110 of Evidence Act deals with options. We have documentary evidence, exclusion of oral evidence, burden of proof as to ownership. Option D, proof of guilt. The right option of question number 51 is option C, that is proof of burden as to ownership. Proof of burden as to ownership. Question number 52, section 113A of the Evidence Act deals with option A, presumption as to abatement of murder. Option B, presumption as to rape and abatement of suicide by a woman. Option C, presumption as to abatement of kidnap of a girl. Option D, presumption as to abatement of suicide by a married woman. The right option of question number 52 is option D, that is presumption as to abatement of suicide by a married woman. Question number 53. The Supreme Court has legalized living wills and passive euthanasia subject to certain conditions in case of options Aruna Ramachandra Sangbang versus Union of India 2011. Option B, Common Cause versus Union of India 2018. Option C, Gyan Kaur versus State of Punjab 1996. Option D. Chena Jagadishwar versus State of Andhra Pradesh 1988. The right option question number 53 is option D, that is Common Cause versus Union of India 2018. The Supreme Court has legalized lying wills and passive euthanasia subject to certain conditions as to the case. Common Cause versus Union of India 2018. Question number 54. Article 310 of Constitution mentions about options. We have doctrine of humanities and instrumentalities with reference to civil servants. Option B, doctrine of legitimate expectation with reference to civil servants. Option C, doctrine of natural justice with reference to civil servants. And option D, that is doctrine of pleasure with reference to civil servant is the right option is option number D, that is doctrine of pleasure with reference to civil service. Civil servant is Article 310 of Constitution mentioned about the doctrine of pleasure with reference to civil servants. Question number 55. Right to know the antecedents of the candidates in the election flow. From option we have 19(1)(a), option B Article 20, option C Article 13, option D Article 14. The right option is option A, that is Article 9, Article 19, Clause 1, Sub Clause A. Question number 56. In the preamble of the Indian Constitution, the expression liberty is followed by the words. Options we have option A, of status and opportunity. Option B, of thought, expression, belief, faith, and worship. Option C, assuring the dignity of individual. Option D, justice, social, economic, and political. Right option is option B, that is of thought, expression, belief, faith, and worship. The liberty of thought, expression, belief, faith, and worship. Question number 57. The plea bargaining is applicable only in respect of those offences for which punishment of imprisonment is up a period of 7 years, 10 years, 11 years, 14 years. Right option is option A, that is 7 years. Question number 58. From a plain reading of section 195 CRPC, it is manifest that it comes into operation at the stage when the court intends to take cognizance of an offence under section 190 subsection 1 of CRPC, and it has nothing to do with the statutory power of the police to investigate into an FIR which discloses a cognizable offense. In other words, the statutory power of the police to investigate under the code is not in any way controlled or circumscribed by Section 195 CRPC. This was held by the Supreme Court in the case of options we have Nalini versus State of Tamil Nadu, option B, Raj Singh versus State 1998, option C, Samsher Singh versus State of Punjab, option D, State of Himachal Pradesh versus Tara Datta. Right option is option B, that is Raj Singh versus State 1998. Question number 59. The question is whether A owes B rupees 10,000. Which of the following statements are relevant under Evidence Act? The facts that A asked C to lend his money. Option B. D said to C in A's presence and hearing, I advise you not to trust A, for he owes B 10,000 rupees. Option C. He went away without making any answer. Right option is option D, that is all of the above. So, in with all these facts, it can be assumed that that will be the question, that whether A owes B rupees 10,000, in which the facts that A asked C to lend him money. Option B, D said to C in A's presence and hearing, I advise you not to trust A, for he owes B 10,000 rupees. Option C, A went away without making any answer. Question number 60. So much of such information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered by the police, may be proved under Section 25 of Evidence Act, Section 26 of Evidence Act, Section 27 of Evidence Act, Section 29 of Evidence Act. Right option is option C, that is Section 27 of Evidence Act. Question number 61. When the court has to form an opinion upon a point of foreign law or of science or art, or as to identity of the handwriting or finger impressions, the opinions upon that point of persons especially skilled in such foreign law, science or art, or in questions as to identity of handwriting or fingers impressions are relevant facts. This is under dash of the Evidence Act. Options Section 42, Section 45, Section 50, Section 55. The right option is option B, that is Section 45. Question number 62. A intentionally and falsely leads B to believe that certain land belong to A, and thereby induce B to buy and pay for it. The land afterward becomes the property of A, and A seeks to set aside the sale on the ground that at the time of the sale he had no title. He will not be allowed to prove his want of title. Which section of the Evidence Act is applicable? Section 92, Section 124, Section 115, Section 101. The right option is option C, that is Section 115. Question number 63. The Arbitration Act 1996 repeals the Arbitration Act 1940, the Arbitration Protocol and Convention Act 1937, the Foreign Awards Recognition and Enforcement Act 1991, 1961, or all of the above. Right option is option B, that is the Arbitration Protocol and Convention Act 1937. Question number 64. Parliament may by law establish administrative tribunals under dash of the Constitution. Options we have Article 323B, Article 323A, Article 333, Article 323. Right option of question number 64 is option B, that is Article 323A. Question number 65. The Bar Council of India has to lay down the standards of professional conduct and etiquette for the advocates under Section 3 of Advocates Act 1961, option B, Section 7, subsection 1, clause B of the Advocate Act 1961, option C, that is Section 17 of Advocate Act 1961, option D, Section 18 of Advocate Act 1961. The right option of question number 65 is option B, that is section 1, that is section 7, subsection 1, clause B of the Advocate Act 1961. Question number 66. According to Section 49 of the Advocates Act 1961, the Bar Council of India has the power to make rules. Option A. Qualifications of membership of a Bar Council and the disqualification for such membership. Option B. The class or category of persons entitled to be enrolled as advocates. Option C. The standards of legal education to be observed by universities in India and the inspection of universities for that purpose. Option D. All of the above. The right option, question number 66, is option D, that is all of the above. Question number 67, India, that is Bharat, shall be option A, Federation of States, option B, quasi federal, option C, Union of States, option D, unitary state of a special type. Right option is option C, that is Union of States. Question number 68, in MC Mehta versus Union of India, AIR 1987, Supreme Court 1086 Sri Ram Fertilizers case, the court held that option A, in escape of toxic gas, the enterprise is strictly and absolutely liable to compensate all those who are affected by the accident, and such liability is not subject to any of the exceptions which operate. Vice versa, the tortious principle of strict liability. Option B. In escape of a dangerous animal, the owner is strictly and absolutely liable to compensate all those who are affected by the accident, and such liability is not subject to any of the exceptions which operate. Vice versa, the tortious principle of strict liability. Option C. In escape of toxic gas, the enterprise is strictly liable to compensate all those who are affected by the accident, and such liability is subject to any of the exceptions which operate. Vice versa, the tortious principle of strict liability. Option D. A company or a corporation is not a state and hence not liable for leak of toxic gas affecting the health of the people. The right option, question number 68, is option A, that is in escape of toxic gas, the enterprise is strictly and absolutely liable to compensate all those who are affected by the accident, and such liability is not subject to any of the exceptions which operate. Vice versa, the tortious principle of strict liability. Question number 69. According to Environmental Protection Act 1986, environmental pollutant means option any solid, liquid, or gaseous substance present in such concentration as may be or tend to be helpful to environment. Option B, only gaseous substance present in such concentration as may be or tend to be injurious to environment. Option C, any solid, liquid, or gaseous substance present in such concentration as may be or tend to be injurious to environment. Option D, any solid liquid present in such concentration as may be or tend to be injurious to environment. The right option, question number 69, is option C, that is any solid, liquid, or gaseous substance present in such concentration as may be or tend to be injurious to environment. Question number 70. National Green Tribunal cannot exercise its jurisdiction with reference to options. We have Wildlife Protection Act 1972, option B, Scheduled Tribes and other traditional forest dwellers recognition of forest rights act 2006, option C, the Public Liability Insurance Act 1991, option D, both A and B. Right option is option D, that is both A and B. Question number 71. An attempt to acquire sensitive information such as usernames, passwords, and credit card details, and sometimes indirectly money by masquerading as a trustworthy entity is an electronic communication is known as electronic communication is known as farming, smishing, phishing, or diddling. Right option is option C, that is phishing. Question number 72. Under Section 82 of the Indian Penal Code, nothing is an offence which is done by a child under the age of options we have 14 years, 7 years, 18 years, 21 years. The right option is option B, that is 7 years. Question number 73. RV Dudley versus RV Dudley and Stepan stands for the principle that option A, killing an innocent life to save his own is not a defense and necessity cannot be pleaded as a defense against murder. Option B, necessity can be pleaded as a defense against murder. Killing an innocent life to save his own may become inevitable. Option C, killing out of mercy is a defense and necessity cannot be pleaded as a defense against murder. Option D, none of the above. The right option is option A, that is, killing an innocent life to save his own is not a defense and necessity cannot be pleaded as a defense against murder. It was held in R.B. Dudley vs. Stephen case. Question number 74. The utility of public interest litigation. Option A, liberalized locus standi. Option B, the proceedings are non-adversarial. Adversarial. Option C, procedural requirements are liberalized. Option D, all of the above. The right option is option D, that is all of the above. Question number 75. The petitioner, a professor of political science who had done substantial research and deeply interested in ensuring proper implementation of the constitutional provision, challenged the practice followed by the state of Bihar in re-promulgating a number of ordinances without getting the approval of the legislature. The court held that the petitioner, as a member of public, has sufficient interest to maintain a petition under Article 32. This relates to the case of option A, Permanent Katara or Katra versus Union of India, AIR 1989 SC 2039. Option B, DC Wadhwa versus State of Bihar. Option C, Neeraja Chaudhary versus State of Madhya Pradesh. Option D, Chameli Singh versus State of UP. The right option is option B, that is DC Wadhwa versus State of Bihar. Question number 76. Where a legal wrong or a legal injury is caused to a person or to a determinate class of persons by reason of violation of any constitutional or legal right, or any burden is imposed in contravention of any constitutional or legal provision or without authority of law, or any such legal wrong or legal injury or illegal burden is threatened, and such person or determinate class of persons by reason of poverty, helplessness, or disability, or socially or economically disadvantaged position, unable to approach the court for relief. Any member of public can maintain an application for an appropriate direction or order or writ in the High Court under Article 226, and in case any breach of fundamental rights of such persons or determinate class of persons in this court under Article 32, seeking judicial redress for the legal wrong or legal injury caused. Where we were, direction, order, writ, or helpless disability. Any constitutional or legal provision or without an authority of law, or any such legal wrong or legal injury or illegal burden is threatened, and such person or determinate class of person by reason of poverty, helplessness, or disability, or socially or economically disadvantaged position, unable to approach the court for relief. Any member of public can maintain an application for an appropriate direction, order, or writ in the High Court under Article 26, and in case any breach of fundamental rights of the such persons or determinate class of persons in this court under Article 32, seeking judicial redress for the legal wrong or legal injury caused to such person or determinate class of persons. Justice Bhagwati, in case of option we have option A, People's Union for Democratic Rights versus Union of India. Option B, Ashok Kumar Pandey versus State of West Bengal. Option C, SP Gupta versus Union of India. Option D, Janata Dal versus HC Chaudhary. Right option of question number 76, option C, that is SP Gupta versus Union of India. Question number 77. Imposition of compensatory costs in respect of false or vexatious claims or defenses is dealt under options. We have 33 of CPC, 35A of CPC, 30 of CPC, 35 of CPC. Right option is option B, that is section 35A of CPC. Question number 78. Which provision under Code of Civil Procedure deals with substituted service of summons upon defendant? Order 5, Rule 19A, Order 5, Rule 19, Order 5, Rule 20, Order 5, Rule 21. Right option is option C, that is Order 5, Rule 20. Question number 79. Among other things, the function of Bar Council of India includes laying down standards of professional conduct and etiquette for advocates under which section of the Advocate Act? Section 7, Section 8, Section 9, Section 6. Right option of question number 79 is option A, that is Section 7. Question number 80. According to Justice Abbott Perry, what are the seven lamps of advocacy? Option we have option A, honesty, courage, professionalism, wit, eloquence, judgment, and fellowship. Option B, honesty, courage, industry, wit, eloquence, judgment, fellowship. Option C, influence, courage, industry, wit, eloquence, judgment, and fellowship. Option D, honesty, courage, industry, seriousness, uh, eloquence, judgment, and fellowship. The right option of question number 80 is option B, that is honesty, courage, industry, wit, eloquence, judgment, and fellowship. Question number 81. Minimum number of directors in a public company is options we have 3, 10, 12, 5. The right option is option A, that is 3. It is minimum. Question number 82. An associate company in relation to another company means option A company in which that other company has a significant influence but which is a subsidiary company of the company having such influence and includes a joint venture company. Option B, a company in which that other company has a significant influence but which is not a subsidiary company of the company having such influence and includes a joint venture company. Option C, a company in which that other company has a significant influence but which is not a subsidiary company of the company having such influence and does not include a joint venture company. Option D, a company in which that other company has full shares and is a subsidiary company of the company having such influence and includes a joint venture company. The right option of question number 82 is option B, that is a company in which that other company has a significant influence but which is not a subsidiary company of the company having such influence and includes a joint venture company. Question number 83. Section 66A of Information Technology Act was held unconstitutional in the case of options we have Justice K.S. Puttaswamy versus Union of India. Option B, MP Sharma versus Satish Chandra. Option C, Shreya Singhal versus Union of India. Option D, Gagan Harsh Sharma versus the state of Maharashtra. The right option of question number 83 is option C, that is Shreya Singhal versus Union of India. Question number 84. A teacher is not a workman within the purview of Industrial Disputes Act held in the case of option B have the workman versus Grievous Cotton and Corporation Limited and others. Option B, John Joseph Coker, John Joseph Coker versus Bhadange or Badange, BS and others. Option C, Sundarambal versus Government of Goa. Option D, Dinesh Sharma and others versus the state of Bihar. The right option is option C, that is A. Sundarambal versus Government of Goa. Question number 85. According to Factories Act, child means a person who has not completed his 15 year of age. Child means a person who has not completed his 14 years of age. Child means a person who has not completed his 18 year of age. Child means a person who has not completed his 16 year of age. The right option is option A, that is a child means a person who has not completed his 15 year of age. Question number 86. According to Income Tax Act, zero compound bond means A bond. Options we have option A, issued by any infrastructure capital company or infrastructure capital fund or public sector company or scheduled bank on or after the first day of June 2005. Option B, in respect of which no payment and benefit is received or receivable before maturity or redemption from infrastructure capital company or infrastructure capital fund or public sector company or scheduled bank. Option C, which the central government may by notification in the official gazette specify in this behalf. Option D, all of the above. The right option is option D, that is all of the above. Question number 87. Provisions relating to GST are inserted in the Constitution by. Options we have Constitution, the Constitution 101st Act 2016. Option B, the Constitution 102nd Act 2016. Option C, the Constitution 84 Act 2016. Option D, the Constitution 77 Act 2016. The right option of question number 87 is option A, that is the Constitution 101st Act 2016. Question number 88. Suits by persons is dealt under option A, order 44 of CPC, 33 of CPC, 55 of CPC, 22 of CPC. The right option is option B, that is order 33 of CPC. Question number 89. Res gestae or res gestae relevancy effects forming part of same transaction is dealt under Section 6 of Evidence Act, Section 17 of Evidence Act, Section 18 of Evidence Act, Section 20 of Evidence Act. The right option of question number 89 is option A, that is Section 6 of the Evidence Act. Question number 90. The definition of money under GST. The definition of money under GST law does not include. Option B have letter of credit. Option B currency held for numismatic value. Option C pay order. Option D traveler check. Right option is option B, that is currency held for numismatic value. Question number 91. Under Article 279A GST, Council is constituted by. Options we have Prime Minister and his Council of Ministers. Option B, respective governors respective governors of the state. Option C, the President. Option D, a collective body of union and states. The right option is option C, that is the President. Question number 92. The definition of contract is defined under. Option we have Section 2, subsection A of Indian Contract Act. Option B, 2H of Indian Contract Act. Option C, 2D of Indian Contract Act. Option D, that is 2G of Indian Contract Act. Right option is option B, that is 2H of Indian Contract Act. The definition of contract is defined in 2H of Indian Contract Act. Question number 93. The Hindu Succession Amendment Act HSAA 2005 provides for women. Option A, co-partnership rights at par with men. Option B, inheritance rights in agricultural land from her parents at par with her brothers. Option C, inheritance of the self-acquired agricultural land of her deceased husband. Option D, all of the above. The right option of question number 93 is option D, that is all of the above. Question number 94. Section 25 of Hindu Marriage Act provides for. Options we have option A, custody of the children. Option B, permanent alimony and maintenance. Option C, maintenance pendant light. Option D, division of matrimonial property. The right option of question number 94 is option B, that is permanent alimony and maintenance. Section 25 of Hindu Marriage Act deals for is the provision regarding the permanent alimony and maintenance. Question number 95. A Hindu wife had been living with her children, and all the children had been brought up by her without any assistance and help from the husband many years. The wife was entitled to separate residence and maintenance under. Options we have Section 18 subsection 2 F of Hindu Adoption and Maintenance Act, section 18 D of Hindu Adoption and Maintenance Act, section option C, that is section 18 2A of Hindu Adoption and Maintenance Act. Option D, section 18 2G of Hindu Adoption and Maintenance Act. The right option of question number 95 is option C, that is section 18 to A of Hindu Adoption and Maintenance Act. Question number 96, requisites of a valid adoption. No adoption shall be valid unless option we have first, the person adopting has the capacity and also the right to take in adoption. Option second option, the person, sorry, second point, the person giving in adoption has the capacity to do so. Third option, sorry, third point, the person adopted is capable of being taken in adoption. And fourth point, the adoption is made in compliance with the other conditions mentioned in the chapter mentioned under. Option, we have section 6 of Hindu Adoption and Maintenance Act. Option B, Section 8 of Hindu Adoption and Maintenance Act. Option C, Section 12 of Hindu Adoption and Maintenance Act. Option D, Section 10 of Hindu Adoption and Maintenance Act. The right option of question number 96 is option A, that is Section 6 of Hindu Adoptions and Maintenance Act. Question number 97. According to Muslim women, protection of right son Marriage Act 2019, any pronouncement of talaq as defined under the act by a Muslim husband upon his wife by words either spoken or written or in electronic form or in any other manner whatsoever shall be. Option A, void cognizable. Option C, compoundable. Option D, all of the above. The right option of question number 97 is option D, that is all of the above. Question number 98. The unilateral model law and rules do not become part of the arbitration act so as to become an aid to construe the provisions of the act held in the case of options. We have option A, Union of India versus East Coast Board Builders and Engineers Limited. Option B, Union of India versus MC Mehta. Option C, Tata Press Limited versus Union of India. Option D, Union of India versus Indian Change Chrome Limited. Right option is option A, that is Union of India versus East Coast Board Builders and Engineers Limited. Question number 99. According to Section 7, Clause 4, according to Section 7, Subsection 4 of the Arbitration and Conciliation Act, an arbitration agreement is in writing if it is contained in option. We have option A document signed by the parties. Option B, an exchange of letters, telex, telegrams, or other means of telecommunication which provides a record of the agreement. Option C, an exchange of statements of claim and defense in which the existence of the agreement is alleged, alleged by one party and not denied by the other. Option D, all of the above. The right option of question number 90 is option D, that is all of the above. Last question, question number 100. Waiver of right to object deviance from arbitration agreement is mentioned under dash of the Arbitration and Conciliation Act. The option we have section 7, section 4, section 20, section 22. The right option is option B, that is section 4. So this was the previous year question paper of AIBE 15, and this was set number D, which was held in January 2021, and we have finally completed it. And we will do the next, that is AIB 16 previous year question paper in our next video. Till then, do whatever you want to do. Have a good time.